Good afternoon, everyone. Thank you for attending today's status conference regarding procedural matters in docket numbers 2023-8E and 2023-10E. Those docket numbers represent Duke Energy Carolinas LLC's and Duke Energy Progress LLC's 2023 Integrated Resource Plan filing. I'm Jocelyn Boyd. I'm employed by the Public Service Commission. I'd like to introduce my colleagues who are present in the hearing room with me today. They include Staff Attorney Adam Russell, live stream producer Melissa Purvis, WebEx extraordinaire Jackie Knight, and security is being held or conducted and handled, is the correct word I want, by Mr. Joe Biggs. So we will proceed now with taking appearances. And what I'm planning to do, everyone, is combine the parties from both dockets. I think there's one intervener that's not in docket number 2023-10E. Ms. Knight, may I ask if someone else just joined? Thank you. Everybody, please give me 1 second, please. Yes. I have to turn. Let's see. I had Miss Clancy, Mr. Treywick. Okay. If I miss anyone as I call names, I apologize. I was just trying to gather all the names. We'll begin with the applicant for both dockets, everyone. So I think I'm going to have to separate these names. So for Duke Energy Progress, Mr. Wellborn, I have your name, Mr. Sam Wellborn, Mr. DeMarco, Mr. Treywick. Is it Mr. Bryce Wirt, Mr. Wellborn?
Yes, ma'am, that's right.
Okay. Now, I have those names, attorneys, as representing Duke Energy Progress. And then for Duke Energy Carolinas, Mr. Wellborn, you appear in docket number 2023-10E, and Mr. Treywick?
Yes, ma'am. Mr. Brightschwert should also be in both dockets.
Okay.
If not, we may need to...
Hold on a second. Let me check my list. I could have missed his name. I have it right here. And that's my oversight if I've missed it.
If it isn't your oversight, I'd rather, we'll get it fixed today rather than Monday morning. So it's a good flag either way.
Okay, we'll double check. We'll talk again at the very end. Anybody who wants to listen to that conversation, please stay online. I don't see it right now, but okay, we'll come back to that. Thank you, Mr. Wellborn. Okay, so now I will move on to Carolinas Clean Energy Business Association, Mr. Witt, Mr. Richard Witt.
That's correct.
All right. Then is anyone present representing Clean Energy Buyers Association? Very good. Ms. Jaffe?
Yes, I'm here. Good afternoon.
Good afternoon. Thank you for participating. Newcourt Steele? Okay. Ms. Mixon and Mr. Gooding, are you present and representing the South Carolina Coastal Conservation League Southern Alliance for Clean Energy, Upstate Forever, and Vote Solar?
Yes, good afternoon. Emma Clancy is also on the line representing the same parties.
Is she present too? I missed her name. I apologize, Ms. Clancy. Oh, I see your name is Clancy. I apologize. I did not mean to overlook you. I do apologize. I have you marked as present. Okay. Next, we handled Ms. Jaffe, we handled Mr. Gooding, Ms. Mixon, Ms. Clancy. South Carolina Department of Consumer Affairs. Very good. So, on behalf of the South Carolina Office of Regulatory Staff, Ms. Donna Rainey and Mr. Chad Torrey.
That's correct.
Wonderful. Is anyone present representing Total Energies Renewables USA? And we've already recognized Vote Solar's representatives. Walmart Incorporated, Ms. Eaton, are you present?
Yes.
Thank you.
Thank you.
Did I miss anyone? Okay, if everyone is okay with me proceeding to Mr. Wellborn, or Mr. Wellborn, if you don't want to speak on behalf of your client, let us know who, regarding your question related to the conversation I had with the chair this morning about the order of procedure for witnesses beginning on Monday.
Yes, ma'am. I'm happy to speak to it. And thank you for convening this and the council for the parties coming together. I know it's been there's been some back and forth this week. We wanted an opportunity to address the requirement from the chair that the companies consolidate the presentation of our direct and rebuttal testimonies. What that will mean is that we'll be rebutting testimony that is not yet in the record. Our intent in our witness order was an orderly and logical presentation of testimony that naturally follows the testimony that it responds to. We think that because the hearing starts Monday morning and given the statutory timeline applicable to these proceedings, that we don't really have a practical alternative to consolidating the presentation of our witnesses' testimony at this point, but we do intend to file a letter preserving the issue. And we'll include these details in the letter, so no need to transcribe anything, I suppose. But in any case, South Carolina Rule of Civil Procedure 43J provides that the plaintiff has the right to open and close the trial. The party having the right to open shall be required to open in full, and in reply may respond in full. And there's case law reinforcing that rule of civil procedure. While the commission's regulations, as everyone I think on this call is aware, provide that evidence will ordinarily be received from the applicant first and from ORS last, we read that as being at each phase of the case, so including responsive phases. To us, that regulation cannot be logically read to undermine the parties with the burden of proof their right to respond in full under the rules of civil procedure and associated case law. I'm not aware, and I've been a bit under the weather this week, and so maybe we have more digging to do, but I'm not aware of any other proceeding where the commission has required the party with the burden of proof to consolidate the presentation of their testimony. I am aware of other cases where the parties have agreed to do that, or where there's been settlement or stipulations to that effect, but I'm not aware of this issue having come up in a proceeding such as this. So just to kind of close up, our intent, initially was to give the commission the best presentation of the case that we can, an orderly and logical presentation of testimony with rebuttal testimony naturally following the testimony that it responds to. We're working now to revise our approach to the presentation of testimony based upon the guidance sent out this morning and our witness order in light of that communication. We're working on revising that witness order. We're going to work on that over the weekend and get it out to other parties as soon as we get to a stopping point on it. So just wanted to address those concerns that we had, Jocelyn, and flag it. And also note that, a letter formally preserving the issue, we're planning to file that later on.
Okay, so let me make sure I'm understanding what you just said. What you're referring to, what you are stating is that once your it's your client's position that your witnesses' direct testimony should all be heard by the commission first. Then the other party's direct testimony should be heard.
Yes, ma'am, to be
Okay.
followed by the presentation of our
Rebuttal.
testimony. Yes, ma'am. And so we had initially proposed to consolidate some of our witnesses' testimony, but given, you know, pushback from ORS, agreed to bifurcate the presentation of our testimony rather than consolidate portions of it. That was all, of course, before the ruling this morning from the chair on the presentation of testimony.
Okay, so I ask you this for my knowledge. With the testimony that you agreed to consolidate before, which is no longer your position as I understand it, was that direct? I guess it was. It had to have been direct and rebuttal testimony of your witnesses.
That's right. There were
Okay.
6 witnesses that we were, you know, trying to be as efficient as we could while also, you know, preserving our right to present testimony in response.
Okay, I have another question. So I was starting to ask you, in your latest proposal, it's your preference, your client's preference for the company's direct testimony to be presented first, then all of the parties direct to be presented first, then the company's rebuttal, and then all of the parties surrebuttal. And my reason for asking, I heard you say something about your client presenting last. I may have misunderstood you.
And I may have misspoke. So yes, ma'am. So the vision would be for the companies to present their direct testimony, all other parties to present their own direct testimony, the parties to present their rebuttal testimony, and then other parties present their rebuttal testimony.
Okay, and you're saying that's because you don't want to present your client's rebuttal testimony prior to the other party's direct testimony, because if you do, you're basically responding to testimony that's not a part of the record yet. If your witness's testimony is made part of the record prior to all of the parties' direct testimony becoming part of the record.
That's right. So if we're presenting rebuttal testimony prior to other parties presenting their direct testimony, we're essentially making other parties' cases for them and then responding to it as part of our direct case, which, you know, in our view conflicts with that rule of civil procedure that I mentioned earlier.
Okay, may I look up something right quick? I'm just gonna. Okay, I'm looking at Rule 43J, but in this sense, where the word "close" is used, I think you're referring to, Mr. Welborn. The closing would be the closing argument will be the rebuttal company's rebuttal testimony being presented after the direct testimony of the other parties.
Yes, ma'am.
Okay.
If you see that last sentence, so the party having the right to open shall be required to open in full, and any reply may respond in full. So, you know, and this is all subject to our previous arguments about the propriety and of sir rebuttal testimony. I don't want to get
Yeah,
go
yeah.
down that rabbit hole in this, this call necessarily. But
Yes, sir. Yes, sir.
we also have our own reservations about sir rebuttal testimony, but.
Yes, sir.
But the ability of the party with the burden of proof, which in this case is the companies, to respond in full, means something. And I think that right is abridged when we're going to get up and down in the first phase of the case and not have any opportunity to put witnesses back up in order to respond to testimony that other parties proffer throughout the course of the proceeding.
May I just ask? I hope you don't mind me asking this question, Mr. Russell. May I ask this? When you say in full too, Mr. Welborn, are you basically would be covering more than just what's been pre-filed? Are you, when you say in full, you mean perhaps questions that were answered on cross and or commissioners' questions? So here's my, as an example, I'm a witness, but I'm a witness for an intervener, and in order for you, the moving party, to respond in full to my answers on cross or from the commissioners, you need to know what I say or what I've testified to while on the stand before you present your rebuttal testimony?
Yes, ma'am, that's right. And frankly, I think it's for both. So it's not only for pre-filed rebuttal not only for pre-filed direct testimony from other parties, but also what's elicited throughout the course of the proceeding. There's a utility services case that stands for the proposition that the party with the burden of proof has the right to respond to new evidence that comes out during the course of a hearing. And so, I think it's both and, but certainly including new matters that are raised or that come up throughout the course of the hearing.
Mm-hmm. Okay, I'm gonna take it one step further. You can say, Ms. Boyd, I don't want to answer that question. So let's suppose that one of your witnesses is testifying regarding the witness's rebuttal testimony. I think what you're saying, and maybe in part, is that you envision the scope of that testimony going outside of potentially what's been pre-filed on rebuttal.
It's possible that there are matters that we would want, one of our witnesses to respond to that comes up during the hearing. I don't know if that answers your question. It does. It's
'cause I was just saying that I was trying to envision what couldn't be anticipated, and the only thing I can envision that can't be anticipated that is testimony during the hearing is what's brought up on cross, because everything is basically pre-filed with the commission. So I think you've answered my question. You maybe, if I misspeak, please let me know. There's the potential for the witnesses or a witness's testimony on rebuttal to cover information or testimony that's beyond the scope of what's been pre-filed with the commission in the rebuttal testimony.
And that's particularly so given the questions that the commissioners tend to ask. So, the universe of what our direct testimony is limited. Other parties file direct testimony, we file rebuttal, and then other parties file surrebuttal. And so there are things that come up throughout the course of a hearing that, frankly, the party with the burden of proof, the utility in this case, needs to be given a meaningful opportunity to respond to. So again, it's, there's a utility services case, it's an administrative due process matter, and we can include, again, more details in a letter filing with the commission. But to us, it's a due process right to respond to new evidence that comes out, throughout the course of the hearing.
Okay, Mr. Welborn, you're going to get tired of me, but this is my mind again. Let me ask you this. If the direct and rebuttal is presented at the same time, and that happens for the companies rather, and then all the other parties are, present their direct and surrebuttal testimony. can those new issues be dealt with in I don't want to call it the third phase, but if the first phase is the company's direct and rebuttal, and the second phase is the intervener's direct and surrebuttal, what's wrong with the third phase that addresses any new issues? I'm just asking. If you don't want to answer, you don't have to answer. I'm not the chair of the commissioners, but if you have any thoughts.
I want to make sure I'm understanding the question.
Okay.
Are you suggesting that the commission would give us, so we do believe that the companies have a right to recall witnesses. Is that what you're referring to?
Basically, yes, sir.
Yeah. And so, yeah, it wouldn't be as orderly, right? It wouldn't be as orderly as putting up our direct case and then putting up our rebuttal case at the end. But certainly, I think the commission, we would like for the commission to recognize our right to be able to recall witnesses should new matters be raised. And then certainly, if we do recall or attempt or propose to recall a witness, that we be allowed to do that, if that makes sense.
Thank you for being patient with me. Let me talk to my colleague to see if he has anything. Okay, I'll be right back. Mr. Wellborn, thank you so much. I'm going to move on to the other parties, unless you have something else.
No, ma'am. Thank you.
Thank you. All right, let's see who's next. Mr. Witt, do you have anything you want to add this afternoon?
SEBA has no comment.
Thank you, Mr. Witt. Next, we have Ms. Jaffe.
Yes, thank you. I guess my initial response would be that, that Sierra Club has always combined its direct and its surrebuttal testimony at the same time, and we would ask that we be allowed to continue to do so along with other interveners. It's more efficient. We've never had an issue with the utilities in the past being able to ask whatever questions they deem appropriate or having new issues raised outside the scope of what's already been filed. We've also asked in conjunction with our joint testimony that was filed with the other parties that we do have some constraints with respect to Michael Goggins' testimony dates. We have requested that he be allowed to testify either on Wednesday or Thursday. So if he had to come back for surrebuttal, we would have some challenges getting him back either down to South Carolina or to participate virtually.
Thank you, Ms. Jaffe. Mr. Gooding, Ms. Clancy, and Ms. Mixon. May I ask if you have any comments, please?
Yes, thank you, Ms. Boyd. Just echoing some of Ms. Jaffe's comments. I'll say it first. We don't necessarily have any strong objections to either the company splitting its witnesses up or to presenting consolidated testimony, but we would certainly appreciate some clarity around which approach that the commission would prefer and that the company is planning to follow in advance of the hearing starting on Monday. And again, as Ms. Jaffe said, when we filed our witness order for our joint witnesses, we did have some scheduling constraints for our witnesses. And so just wanted to note that, regardless of which approach that the companies take, we would like to present our witnesses' direct and surrebuttal testimony together. In addition to Mr. Goggins' constraints, witness Turk also had some scheduling constraints, and we requested that he be able to testify on a date certain of September 19th. Witness Duncan will also be traveling, and so to the extent that we are able to present his testimony at the same time, we would certainly appreciate that. Thank you.
So you want Mr. Turk and Mr. Duncan to testify on the 19th?
So our witnesses, witness Rumpani and
Yes.
witness Duncan do not have specific days that they need to testify
Okay.
on. But we would like for them to be able to testify on one day versus having to come back twice.
Okay. When you say one day, you mean the same day?
Yes.
Okay.
Meaning presenting their direct and their
Yes, ma'am.
testimony together.
All right.
Ms.
So your
Moore.
request is that for witnesses Duncan and Rupani to testify on the same day, and Mr. Turk needs to testify on the 19th, which is Thursday, I think.
No, so for clarity, what I mean is that for each of witness Rapani and witness Duncan, each of them could testify on a different day.
Yes.
Like
Yes.
Rapani on the 18th and Duncan on the 19th or whatever it may be. But that when they testify, they present both of their testimonies together so that we do not have to recall them at a later date in the hearing.
Ms. Boyd.
Yes, sir. Yes, sir.
Now that this discussion has come up, I do need to comment for Sasiba. We filed a written request back on September the 4th that our witness, Mr. Haggerty, be allowed to present his testimony as part of a panel with Hamilton Davis on the 19th. We don't have the problems that the other council have because we only have direct testimony for both of our witnesses, but we did make that request for them to appear on the 19th back on in writing to the commission on the 4th of September.
Okay, and I'm thinking the chair is going to rule on those Monday morning.
All right, thank you.
Okay, thank you for mentioning that. Okay. Let's see. Ms. Clancy, is that all you have right now?
Yes, that's all. Thank you, Justin.
Did I call the right? Yes, I'm sorry, Ms. Mixon. I apologize. Not Ms. Clancy. Okay. Okay, let's see. Ms. Rainey and Mr. Torrey.
Hey, John, this is Chad Torrey. I think ORS's position is pretty clear in the letters that it has filed that we believe the most efficient and orderly manner is to proceed as we typically do, and that's for the presentation of direct and rebuttal together and direct and rebuttal together. But I did want to, I just wanted to clarify the procedure proposed by Mr. Welburn. So that would be company direct, all other parties direct, company rebuttal, and all other parties rebuttal. Is that?
Yes,
correct?
sir. I think that that's my understanding. Yes, sir. So the company would present its direct, and then Office of Regulatory Staff and the other interveners would present their direct, and then the company would present its rebuttal, and then the Office of Regulatory Staff and the other parties would present their rebuttal.
I could offer one clarification to that if helpful. Sorry to interject, Chad. Just that I understand that certain parties do want to consolidate the presentation of their testimony. For example, SACE and CCL's witnesses have certain availability issues that they're trying to navigate. And so if there's a date certain, for example, that, another party needs to present their testimony, we can attempt to accommodate that. But we included our order of witnesses in a September 4th letter and a September 11th letter. And I think either of those we would be comfortable with in terms of splitting up direct and rebuttal.
Okay, and the reason I just wanted to clarify that proposed order, Sam, is you mentioned Regulation 103842 with the provides ORS generally goes last, and I didn't know if you were saying that this was an exception to the rule that ORS would not go last in this instance.
Trying to get my camera working again. No, so we would not be proposing anything different from that. What we're proposing is that direct be presented separately from rebuttal. So again, we would present direct testimony. Other parties would present their direct testimony. ORS would present its direct testimony. we would present our rebuttal testimony, and then other parties would present their rebuttal testimony.
Okay, I figured that's what it was, Sam. I just wanted to confirm. Jocelyn, that's all
That's
we
all.
have.
Thank you so much. Okay. Miss Eaton.
Hi there. We don't really have a preference for how the testimony is presented. We have only filed direct testimony of our witness, Ms. Perry. I think I right now don't foresee any time constraint or date constraint with her testimony, although it would be best if it was not Friday the 20th. So any of the days before then, but not Friday. However, I think I do recall us in the past always presenting parties direct and rebuttal, or direct and rebuttal together at the same time. But we don't have any objection to however Mr. Wellborn has proposed to do it either. It just might take longer in terms of the hearing time. So however the commission wants to do it is fine.
Yes, ma'am. Thank you. Did I miss anyone unintentionally? Okay, so Miss Mixon asked for clarity prior to this case beginning on Monday, and I can't make any commitments right now. We'll have to talk to the chair, Ms. Mixon, about what will happen next. But Mr. Wellborn, I want to make sure that when we talk to the chair, that I'm not putting words in your mouth. I clearly understand I clearly understand that your proposal now is for direct rebuttal, rebuttal, that order. But I wanted to ask about the twist that I mentioned, that if how strongly opposed you are, and you don't have to answer right now, to direct and rebuttal being presented at one time, direct and rebuttal being presented at one time, and then if there are new issues, being able to recall any of your witnesses that you think that you need to respond to those new issues.
Yes, ma'am. I affirm the company's, desire, I guess, to be able to. It's weird to say you desire to exercise a right, but we do intend and would like and preserve, the right to recall witnesses should, new matters be raised while other parties' testimonies is being delivered to the commission. So in other words, yes.
You're okay with that?
Well, I won't say that I'm okay with it. The order of witnesses that we proposed on September 4th and 11th are the ones that we would
That's your preference.
Advocate for.
Yes, sir.
And practically speaking, I guess, kind of to Ms. Mixon's point, it's the hearing starts in a few business hours from now.
Yes, sir.
And so, practically we may be log jammed at this point. But, having the right to recall or being able to exercise the right to recall certainly is something that the companies, would be interested in and likely, would want to preserve throughout the course of the hearing.
Yes, sir. Do you understand what I was saying, Mr. Russ? Okay, yeah. No, I'm not. Of course, I don't have the authority to make the decision, but when the representation is made, I wanted to make sure that we're representing we understand your position. It's in writing in September 4th, September 11th. And I was just asking about this third potential and where you stand on that. So, okay.
I do have one other
yes, sir.
question, I guess, before folks start to drop off. There have been, as you're aware, motions filed in this proceeding. Should the parties be planning to argue those motions Monday morning? At
Yes,
the
sir.
start of the hearing?
I think so. Yes, sir.
Okay.
Yes, sir.
Thank you.
You're welcome. Okay, well, Ms. Purvis has done a magnificent job preparing for everyone's arrival on Monday morning in the hearing room. So I hope that you all have a safe weekend, and we look forward to seeing you, if not in person, virtually, starting Monday.
Can I ask you one more question?
Yes, ma'am.
I still have the problem getting on to
You do?
the survey.
Okay. Miss Eaton with Walmart is having an
Yeah.
issue. Are you having a problem? Oh, you're having a problem responding to the media plan survey, Miss Eaton?
I can't, yeah. And so I wanted to be able to advise who is going to be there and when. And
Okay.
I can't do it because it is not,
Okay, Miss Eaton, stay on, if you don't mind, stay right there.
okay.
I'm sorry, Mr. Welborn. We were supposed to come back to something. Oh, Mr. Bryce, were you able to check that docket? Remember?
Yeah, so Mr. Brightshort is pro-hocked into, I believe, -8.
Okay. Okay.
That's consistent with how that's been handled in the past, as I understand it, since they're, the hearings will be concurrent or effectively consolidated, if not formally. He's only pro-hocked into the one, but we don't see that as being an issue.
Okay. All right. So what I'm going to do, I'm going to call Ms. Goodfellow. Ms. Eaton, if you're able to stay on right there, and we can get your information.
Just making sure.
Yes, ma'am. And we appreciate that. I told Ms. Purvis, I said, Ms. Eaton's always here, but I was wrong. No, she's going to have some more people. So we're going to get after. Ms. Eaton, how many more people?
Well, there may be, and one of my colleagues coming there on Friday. And
Okay.
I guess if this hearing lasts so long that it goes into the second week,
Mhm.
which hopefully it won't, but if that happens, I can return back. But I've got kind of a pre-existing commitment on Friday, like a paid CLE thing that I have to go to.
Right.
And so, and our witness needs to be participating virtually because she's just coming back in town from another country, and it would be much better for her to not also travel to South Carolina on the heels of that. So
Okay.
I just wanted to provide the relevant information,
Yes, ma'am.
and I still haven't been able to do it.
Yeah, you stay right there if you don't mind. I'm getting the staff that will handle that for you to make sure that you're comfortable with everything. So if you stay on, does anybody
All
else?
right, sure.
Yeah. Does anybody else have anything else they want to talk about today?
Yeah, this is Miss Jaffe with Sierra
Hey,
Club.
Miss
I was
Jaffe.
gonna echo that I had the same problems with the form. I did technically fill it out, but I filled it out as an ABC company and then inputted my information, Mr. Giles, and our experts. So I just wanted to make sure that was received because there was no drop down option for the Sierra Club.
Yes, and Ms. Jaffe, if you stay right there too, because what we did is we were using Constant Contact, I want to say, for our surveys, and the commission we invested in Smartsheet last year, and Pam McMullen was able to expand our use of that platform to create surveys. So I want to get her in here too, so that she can understand what you're experiencing. Now, I do know she did tell me for that drop-down box, if the name has not been used before, I don't think that the entity's name will appear in the drop-down, but you should be able to type your client's name in that field.
Yeah, Mars just says ABC company.
Yes, ma'am.
I didn't want to pick that in case.
Right.
That's not, it's not reflecting the actual party that we're representing.
That's correct.
So before I go about doing all that.
Right. So I want to make sure that we handle your issues too. Did anybody else have any problems? Yeah, I asked Ms. Jaffe and Ms. Eaton to stay where they are. I need to find. Okay, does anyone else have any other issues? Because we're gonna ask Ms. Eaton and Ms. Jaffe to stay where they are live so we can address their issues. If not, I hope you have a good weekend, everyone. Ms. Jaffe and Ms. Thank you.
Thank you, Jocelyn. Take care.
Hey, I need you to come in the hearing room and bring Afton with you if you don't mind.